Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. Today we'll be looking at the question: what are the employer's responsibilities when terminating an E-3 employee? Let's get started. The E-3 visa, which is a non-immigrant visa reserved for nationals of Australia, can be an excellent option both for Australians who want to live and work in the United States, as well as US employers who would benefit from the expertise offered by an Australian worker. Unfortunately, sometimes it is necessary for an employer to terminate an E-3 worker. In this video we consider what the employer's obligations are when they terminate an E-3 employee.
1. The employer should notify the employee of the termination in writing, and should offer to pay for the employee's return travel.
The employer should provide the terminated E-3 worker with written notice that their employment has been terminated. The notification should include the effective date of the termination. The employer should also offer to pay the E-3 employee for the cost of reasonable transportation to their country of last residence. The employer can either purchase the tickets directly, or can pay the employee the cash value of the transportation. Keep in mind that the employer only needs to pay for the employee's return transportation if the employer terminated the E-3 employee. In other words, the employer does not need to pay for the employee's travel if the employee voluntarily resigns or chooses not to leave the United States. Also, the employer does not need to pay for the return transportation costs of the E-3 employee's dependents such as their spouse and children.
2. The employer should also give written notice of the termination to U.S. Citizenship and Immigration Services, if the petition was filed with USCIS, and should ask the Department of Labor to withdraw the labor condition application.
If the E-3 petition was filed with USCIS, the employer should provide written notice of the termination to USCIS. The employer can do this by sending a letter to the specific USCIS service center that adjudicated the petition, and letting them know that you would like to withdraw the E-3 petition, since the E-3 employee has been terminated as of a specific date. USCIS will then send the employer a notice revoking the petition. The employer should keep both a copy of their letter to USCIS, and the notice returned by USCIS. Similarly, the employer should reach out to the U.S. Department of Labor, and notify them that you would like to withdraw the labor condition application that was filed with the E-3 petition.
3. The employer should also keep documentation of the termination.
Taking the steps listed in the previous slides, and keeping documentation showing that these steps were taken, is important for a number of reasons. Among other things, the employer's failure to take these steps could entitle the E-3 employee to back pay. Remember that the employer is required to pay the E-3 employee until their employment is actually terminated. As a result, the employer could be responsible for back wages if they stop paying the E-3 employee before there has been a bona fide termination. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.